You can be smart and still do stupid things. A woman inherits her mother's house. She grew up in that house. She knows every room, every squeaky floorboard, every tree in the backyard. Mom paid 80 grand for it in 1987, and it's worth 420 grand today. And because Mom had lived there since 1995 and established her homestead exemption, the property taxes were locked in at just under 2 grand a year under Florida's Save Our Homes cap. The daughter wants to keep it. She's always wanted to keep it. She's been planning to keep it her whole adult life. Then the tax bill arrives. Not $2,000, not even close. The county has reassessed the property at current market value, $420,000. And the new annual tax bill is $11,200, almost 6 times what Mom was paying. And it arrived, not gradually, not with a warning, but all at once. The first full tax bill after the transfer. She cannot absorb it. She does not have an extra 9 grand a year sitting around. Nobody told her this was coming. Nobody told her the cap dies with her mother. Nobody told her that the moment that property changed hands, the county was going to look at it with fresh eyes and charge her accordingly. She sells the house she grew up in, the house her mother worked 35 years to own free and clear. She sells it, not because she wants to, but because a tax bill she never saw coming made the decision for her. 35 years of mortgage payments, 35 years of maintenance and upkeep and property taxes, 35 years of her mother's life in that house, gone because nobody told her. That is the tax reassessment blindside. And in Florida's current market, where property values have increased dramatically over the past decade, the gap between what a long-term owner pays in taxes and what an heir will pay after reassessment has never been wider. I've seen that gap destroy plans family had been building for years. But that's only the first half of today's video. Because even if your heirs can handle the tax bill, even if the numbers work and everyone agrees to keep the house, there is still one more trap waiting. And this one does not come from the government. It comes from inside the family. Hey, I'm Tom McNamara, Florida Real Estate Insider. This is video 7, the second to last video in our series on the 6 good ways people accidentally wreck their kids' inheritance. If you're just joining us, go back and start from video 1. The links are in the description. And hit subscribe and ring that bell. Video 8 ties the whole series together, and you don't want to miss it. As always, I am not your attorney, and this is not legal advice. Everything I tell you today is the beginning of your education. A qualified real estate attorney licensed in your state is the end of it. Are we good? All right, let's go. Let's start with the tax reassessment. And make sure you understand exactly how this works in Florida, because the mechanics of it are not complicated, but the consequences are significant and almost nobody sees them coming. Florida's Save Our Homes cap was created to protect long-term homeowners from being taxed out of their homes as property values rise. Once you establish homestead exemption on a Florida property, the assessed value for tax purposes can only increase by a maximum of 3% per year, or the rate of inflation, whichever is lower. In a market where property values have been rising 8, 10, 12% a year, that cap is enormously valuable. It is one of the best homeowner protections in the country. If you've moved to Florida from another state, this is probably not something you had back home. Most states do not have anything like it, which means most people who move here have no framework for understanding what they're about to lose when they pass it to their heirs. But here's what makes it a double-edged sword. That cap is the greatest tax benefit for the owner and the biggest liability for the heir. Save Our Homes went into effect on January 1st, 1995. That means the maximum protection anyone could have accumulated is about 30 years. And in Florida's appreciation market, 30 years of 3% capped increases on a property that's been growing at 8 to 10% a year creates an enormous gap between what the owner pays and what the property is actually worth. That gap is the tax bomb your heirs are going to inherit. The moment that property transfers, the county property appraiser typically resets the assessed value to full current market value. And that new assessed value becomes the basis for every tax bill going forward. Let me show you what that really looks like with real numbers. A property bought in 1995 for $120,000 is now worth $500,000. 30 years of Save Our Homes protection, the maximum accumulation possible since the cap took effect in 1995, has kept the assessed value at roughly $200,000. The owner pays approximately $3,000 a year in property taxes. The owner passes. The property transfers to the heir. The county reassesses at $500,000. The new annual tax bill lands at approximately $7,500 to $10,000, depending on the county and applicable exemptions. That's an increase of $4,500 to $7,000 per year, every year, starting immediately. Now, I have to pause here for a second because I know what some of you are thinking. You've heard the news out of Tallahassee. You've seen the headlines about eliminating property taxes on homestead properties entirely. And yes, wouldn't that be something? If you own your home and have your homestead exemption filed, the idea that you would pay zero property taxes is genuinely appealing. Governor DeSantis has been pushing for it. The Florida House actually passed a version of it in February of this year. But here's where we are right now. The Senate hasn't moved on it yet. Even if both chambers pass it, it goes to Florida voters in November 2026 and needs 60% approval to become law. That's a high bar. And even the most optimistic version of this would not take effect until January 2027 at the earliest, with some proposals phasing it in over 10 years. So watch this space. It's a real conversation, and it could change everything we just talked about. But right now, today, the reassessment problem is real. The tax bill is real. And planning around what might happen is not a strategy. Plan for the law as it exists. If Tallahassee delivers something extraordinary, that's a bonus. If the heir was planning to keep the property as a rental, that number has just dramatically changed the math on whether that makes financial sense. If the heir was planning on moving in, that number just changed their monthly budget in a way nobody planned for. And if the heir was already stretched thin, if they have their own mortgage, their own family, their own financial obligations, that number can make the decision for them before they even have a chance to think about it. Now, before you panic, and I say this because I want the video to be genuinely useful to you, not just scary, there are escape hatches. There are legal strategies that can prevent or significantly reduce this reassessment. Most people have never heard of them. Let me walk you through each one. Escape hatch number 1, the legal dependent exemption. Under Florida Statute 193.155, a reassessment is not triggered if the property transfers to someone who was legally or naturally dependent on the owner and who permanently resides on the property. In plain English, if the heir was already living in the home and was financially dependent on the parent, they may be able to inherit the parent's low tax basis. The assessment doesn't reset. The low tax bill stays. Here's the catch. This is a high bar to clear. You have to prove dependency to the county property appraiser. That's not a form you fill out online. That's a process that typically requires a real estate attorney to present evidence correctly. But for families where an adult child moved back in to care for a parent, or where a dependent relative has been living in the home, this exception can save thousands of dollars a year. It's worth having the conversation with an attorney before you assume it doesn't apply to you. Escape hatch number 2, the Ladybird deed. We've talked about the Ladybird deed throughout this series, but here's a nuance we have not fully explored yet, and it matters for this specific conversation. Because a Ladybird deed transfers the property at the moment of death rather than before it, it avoids probate. And for certain heirs, specifically a surviving spouse or a minor child, the law generally prevents the full reassessment reset. The low tax basis can survive the transfer. For adult independent children, the picture is much more complicated. A Ladybird deed does not automatically stop the reassessment for an adult child who has their own household and their own finances. The county will likely still reset the assessed value to current market value. But here's what it does guarantee regardless. The stepped up basis we talked about in video 3. Even if the property taxes go up after reassessment, the heir's capital gains tax exposure is 0 if they sell. The Ladybird deed solves the capital gains problem completely for every heir. It solves the property tax problem fully for surviving spouse or minor child, and partially for adult children, depending on the circumstances. This is exactly the kind of nuance that requires an attorney and a CPA in the same conversation, because the right answer depends on who the heirs are, how the property is structured, and what those heirs plan to do with it. I want to pause here for a second because I know this is a lot of information, but I'm walking you through each one of these because any one of them might be the one that saves your family thousands of dollars a year. Don't tune out. The next one might be your situation exactly. Escape hatch number 3, portability. This one is almost completely unknown outside of estate planning circles, and it is genuinely powerful for the right situation. Florida's portability rule allows a homeowner to transfer or port up to $500,000 of their own Save Our Homes tax savings to a new primary residence when they move. Most people know about portability in the context of moving from one home to another, but here's the version that applies to heirs. If the heir already owns a homesteaded property in Florida with their own accumulated Save Our Home savings, and they decide to move into the inherited property as their new primary residence, they can port their own tax savings to the inherited home. It does not preserve the parent's low tax basis, but it does use the heir's own earned savings to knock down the new higher bill significantly. Think of it this way. The county resets the tax bill to $10,000, but the heir has $300,000 in portability savings from their own home. They apply that portability to the inherited property, and the new bill drops to something much more manageable. This is a strategy that requires planning, specifically the decision to move into the inherited property as a primary residence and the proper filing of the portability application within the required timeframe. Miss the window, and the opportunity is gone. An attorney and a CPA need to be looking at this before the transfer happens, not after. Escape hatch number 4, joint tenancy with rights of survivorship. I'm going to be direct about this one because it is technically a solution, but it comes with a serious warning that we've already covered in this series. If an heir is already on the deed as a joint tenant with rights of survivorship, and they also live in the home as their primary residence, and they have established that their own homestead exemption on the property before the parent passes, the assessment generally will not reset upon the parent's death. That sounds great, and in a narrow set of circumstances, it is a legitimate strategy. But go back and watch video 3 before you consider this option, because the moment you put a child's name on your deed as the joint tenant, their half of your home is exposed to their creditors, their lawsuits, their divorce, their tax liens. Joe Siegel explained exactly what that exposure looks like, and it's not theoretical. I've seen it happen. This option works in a very specific situation. An heir who is financially stable, has no creditor risk, no pending legal issue, and is already living in the home. If all those things are true, it's worth a conversation with your attorney. If any of them are uncertain, the risk is not worth the tax benefit. And for those of you thinking about a trust as a solution here, a properly drafted revocable trust preserves the cap while the parent is alive. After they pass, the reassessment still happens for the independent adult child. But the trust gives you the best platform to deploy the other escape hatches and gets the heir to clean title faster. It's not the escape hatch by itself. It's the foundation that makes the other escape hatches work. Talk to your attorney. Escape hatch number 5. And this one is for the investors in the room. Let me paint you a picture. A father owns 3 rental properties in Florida. He's held them for 15 years. Over that time, the 10% non-homestead cap has kept the assessed value on each property well below current market value. We're talking about a combined tax savings of several $1,000s a year across the portfolio. That's real money. He passes away. The properties transfer to his son. The county reassesses all 3 at full current market value. The annual tax bill on the portfolio jumps dramatically overnight. And suddenly the math on keeping those properties as rentals doesn't work the way it used to. That is the non-homestead version of the same problem we talked about earlier. Different cap, same gut punch. Now, here's where it gets interesting. Florida law defines a reassessment trigger on non-homestead property as a cumulative transfer of more than 50% of the ownership of the legal entity that owns the property. In plain English, if more than half of the LLC changes hands, the county treats it as a new owner and resets the tax basis. If less than half changes hands, it may not. So here's what a good estate planning attorney can do with that. If those 3 rental properties are held inside properly structured LLCs, and if the son already owns a meaningful stake in those LLCs before the father passes, the transfer of the father's remaining interest at death may not cross the 50% threshold. And if it doesn't cross that threshold, the 10% cap may survive the transfer entirely. Think about what that means in practice. Dad owns 60% of the LLC, son owns 40%. Dad passes and his 60% transfers to the son. That is a transfer of 60% of the entity, which crosses the threshold and triggers the assessment. But if the attorney structures it differently, if the son already holds 51% and dad holds 49%, then when dad passes, his 49% transfers to the son, and that is below the 50% threshold. The county does not see a change of control. The cap survives. That's not a loophole. That is exactly how the statute is written. And a good estate planning attorney who understands both LLC structure and Florida property tax law can build that plan years in advance so that the ownership percentages are in the right place before anyone needs them to be. On a portfolio of 3 rental properties worth a combined $1.2 million, the difference between triggering that reassessment and avoiding it could be $15,000 to $20,000 a year in additional property taxes every year for as long as your heirs hold on to those properties. That's the number that should be driving this conversation. Here's what I need you to hear about this strategy. First, it has to be set up before it's needed. This is not something you can retrofit after a parent passes. The ownership structure has to be in place, properly documented, with a correctly drafted operating agreement. The time to do this is now, not later. Second, there is a 2023 Florida court ruling that found that simply transferring non-homestead property into an LLC, even one you wholly own, can itself trigger a reassessment at the time of the transfer, which means if the property is not already in the LLC, getting it there needs to be done carefully with an attorney who knows this specific ruling and knows how to structure the transfer to minimize the reassessment exposure at that stage. I'll tell you what I tell every investor who comes to me after the fact. The conversation you should have had 3 years ago is going to cost you a lot more to have today. And that conversation you have today is going to be a lot cheaper than the one that your kids are going to have after you're gone. This stuff is fixable, but it does have a window. Third, and I cannot say this clearly enough, do not put your primary residence in an LLC, ever. Florida courts are unambiguous that an LLC cannot qualify for the homestead exemption. You would lose your 3% cap, your creditor protection, and your homestead exemption the moment you transfer it. The LLC strategy is for investment and rental properties only. Your home stays in your name or in a properly drafted revocable trust. If you own rental properties or investment real estate in Florida and you've never had this specific conversation with an estate planning attorney, you are leaving money on the table and potentially setting your heirs up for a tax bill that changes the economics of everything that you built. This is exactly the kind of conversation that requires your attorney, your CPA, and your financial planner in the same room at the same time, because the LLC structure affects the tax picture, which affects the estate plan, which affects the financial plan. Pull one thread and the others move. You need all 3 professionals looking at the same picture before anyone makes a move. Always consult a state-specific real estate attorney before changing how any of your investment properties are titled. And here's Tom's insider tip before we move on. Even if none of these escape hatches apply to your situation, even if the reassessment happens and the full new tax bill lands, there are still things you can do to soften the impact. And the first one starts before anyone passes away. My friend, Joe Siegel, Florida real estate attorney, someone who I've worked with over a decade, checks homestead exemption status as a matter of routine whenever he sits down with a client. Here's what he told me he finds.
If they have not filed for their homestead exemption with the tax collector or the tax appraiser, do it. I have spoken just this year. I mean, it's March, and I've had at least 3 client consultations this year that, as we're going through things, I always look at their properties and I check their homestead status. And I've had 3 that had not ever filed for their homestead exemption. You still get the creditor's protections, whether you file that or not, but you're not getting the tax benefits. You're not getting the lower real estate tax. You're not getting the caps on valuation, all these things that play into that.
3 clients just this year, already in Florida, already living in their homes, never filed. If you're not certain that your homestead exemption is on file and active with your county property appraiser right now, check today. It takes minutes on your county's website. And if it's not there, filing it costs nothing and starts protecting you immediately. Now, for the heirs, once that reassessment happens and the new bill lands, your first move should be to check every additional exemption that applies to your situation. Florida has reductions available that most people never claim because nobody told them to look. The senior low income exemption, the widow's exemption, the veteran's disability exemption. These do not stop the reset, but they can knock meaningful dollars off the new bill every year going forward. Have your heirs sit down with the county property appraiser's office or with an attorney who can do it for them and find out every exemption that applies. That conversation costs nothing. There's a massive difference between inheriting a house and inheriting a tax bill. Know which one you're getting before the transfer happens. Now, stick with me for just a few more minutes, because everything we just talked about, the tax bills, the escape hatches, the LLC structures, all of it assumes one thing. It assumes your heirs can sit down together, look at the numbers, and agree on what to do. And I need to tell you what happens when they can't. 2 houses, 2 different families, 2 different situations, but the same outcome. Between the 2 of them, there was roughly $500,000 in equity sitting in those properties. Good homes, well-maintained, in solid markets. The kind of inheritance that should have set multiple people up for years. By the time both transactions were done, after the attorneys, after the court costs, after the carry costs, after the partition sales, each sibling in both families walked away with about $30,000. $30,000 out of $500,000. Not because the market crashed, not because there was fraud, not because anyone did anything wrong in a legal sense, because the families fought. They fought over who got what, who was owed what, who had contributed more, who the parents would have wanted to have it. And while they fought, the lawyers billed. And while the lawyers billed, the clock ran. And while the clock ran, the market moved. And by the time there was nothing left to fight over, there was almost nothing left at all. I've never forgotten these 2 transactions, and I never will. That is what sibling warfare looks like in the real world. Not a dramatic court scene, just a slow, grinding, expensive erosion of everything a parent spent their life building, while their children stood on opposite sides of it and watched it happen. Let's talk about how it starts, because it almost never starts with greed. It almost always starts with grief. When a parent passes, everyone's hurting. Everyone's processing loss in their own way. And into that emotional environment, you drop an illiquid asset, a house, a piece of property, something that cannot simply be divided in the way a bank account can. And you ask people who are grieving to make a rational financial decision together. That's a setup for conflict, even in the most loving families. Here is the legal structure that will make it worse. When a property is left equally to multiple heirs without a specific plan, those heirs become what is called tenants in common. Each one owns a percentage share of the whole property. The tenancy in common has one fundamental problem. Every decision requires agreement. Want to sell? Everyone has to agree. Want to rent it out? Everyone has to agree. Want to do nothing and hold it as an investment? Everyone has to agree. And if they don't agree, even if one person refuses, any one of them can file a partition lawsuit. The court steps in, orders a sale, and that sale happens on the court's timeline, not the market's. which usually means below market value. And then the legal fees come out of whatever is left. My friend Joe Siegel has seen this play out at every level, from modest family homes to multi-million-dollar estates. Here's what he told me about how bad it can actually get.
I remember the first law firm I ever worked for, we had a case where daddy had died and his estate was worth, I think, $2 million, which in 1995 was a lot. And the kids fought over his will. Well, he wrote this and you were in the lawyer's office while he signed it. They challenged it, went to the Supreme Court in North Carolina twice. By the time it was over, all the lawyers had gotten very wealthy and the estate was down to nothing.
Yeah. Down to nothing. A $2 million estate gone. Not because of bad investments, not because of market conditions, because the family could not agree and the legal system charged them for every day they couldn't. And here's what I want you to understand about that story. These were not bad people. They weren't greedy people. They were people that loved their father and disagreed about what he would have wanted. And the absence of a clear plan turned that disagreement into a legal war that consumed everything. Now, here's a version of that story that I see more often in Florida. It's not as dramatic, but it's just as destructive.
We've got one. I had one earlier this year. Daddy's estate was very large. One daughter got stuck. Number one, she was his caretaker until he died for a couple of years. Then she ended up being the trustee of the trust, which he had a trust. Everything's been sold. Everything's gone fine for years. And now one spouse of one child is starting to stick their nose in. They're down to one piece of property to sell, and they're sticking their nose in, making trouble. Well, we've got this big old piece of commercial property we need to sell. It's millions of dollars. We need to get it done. And sister girl's spouse is starting to stick her nose in and cause problems, and it's holding everything up. And meanwhile, the market could be tanking while they're arguing over this.
That is the slow version of the same disaster. Not a courtroom fight, just one person, not even an heir, a spouse of an heir, deciding to make things difficult. And because the legal structure requires everyone to agree, one difficult person can stop everything. While the market moves, while the carrying costs run, while the family relationships deteriorate one phone call at a time. I've watched siblings stop speaking over a kitchen table, over a house, over something their parents gave them as a gift. So what do you do about it? Both of these problems, the tax reassessment and the sibling warfare, have the same root cause, a property transferred without a plan. And both of them have solutions that need to be put in place before the transfer happens, not after, before. For the tax reassessment problem, the conversation starts with knowing the numbers. What is the property worth today? What are the current taxes? What will the taxes be after reassessment? Your heirs need to know that number before they decide whether to keep the property, rent it, or sell it. Walking into an inheritance without knowing the carry costs is like buying a car without knowing what the insurance is going to be. The price on the window isn't the whole story. In some cases, there are strategies that can soften the reassessment impact. Certain transfers, including some trust transfers and transfers to a surviving spouse, may qualify for assessment limitations. This is very specific to the structure of the transfer and the relationship to the parties involved. Your attorney and your CPA need to look at this together before the transfer happens, not after. For the sibling warfare problem, the solution is a plan that removes ambiguity, a trust with specific, detailed instructions about what happens to the property, whether it gets sold, who has the right to buy out the others, what timeline applies, who makes the decisions if there is a disagreement, is the most effective tool available. It doesn't eliminate family dynamics, but it eliminates the legal vacuum the family dynamics rush to fill in. A buy-sell agreement among heirs, negotiated and signed while everyone is still rational and the parent is still alive, is another option. It establishes in advance what happens if one sibling wants to sell and another one wants to keep the property. Who buys whom out, at what price, on what timeline. These conversations are uncomfortable to have. They are infinitely less uncomfortable than a partition lawsuit. And the conversation about all of this, the tax numbers, the trust structure, the buy-sell provisions, the carry cost analysis, That needs to happen with your attorney, your CPA, and your financial planner in the same room at the same time, because each piece of this affects the others. The tax strategy affects the trust structure affects the financial plan, and none of it works the way it should if those three professionals are working from different information. Here's your homework before next week. 1, if you own Florida property and you have not had a conversation with your heirs about what the carrying cost will look like after reassessment, have that conversation this week. Pull the current tax bill, look up the current assessed value, go to your county property appraiser's website, and run the numbers at full market value. Show your kids what that bill will look like. Let them make an informed decision about whether keeping the property is actually what they want to do. 2, if you're planning to leave property to multiple heirs, talk to an attorney about how to structure that transfer so it does not create a tenancy in common without a plan. A trust with clear distribution instructions, a buy-sell agreement, or a clearly documented plan of action can prevent years of conflict and tens of thousands of dollars in legal fees. 3, if you're an heir who has already inherited property with siblings and there is no plan in place, get one. It is not too late to create a written agreement about what happens if someone wants out. It's a lot easier to have that conversation now than after someone files a partition lawsuit. 4, check the escape hatches. Does the legal dependent exemption apply to your situation? Does the heir have portability savings they can bring to the inherited property? Is a Ladybird deed the right structure given who the heirs are? These are not questions you can answer from a YouTube video. They are questions for a Florida real estate attorney who can look at your specific situation and tell you which tools apply. 4.5. If you own investment or rental properties in Florida, pull out your LLC operating agreements right now and look at who owns what percentage. Is the ownership structure set up to keep transfers below the 50% threshold? If you don't know the answer to that question, that's the first call you make. 5, before any of those conversations happen, know what your property is worth right now at today's market value, because that number is the foundation of every other decision. I can give you accurate current valuation so your family is working with real numbers instead of guesses. Link is in the description. Next week is video 8, the series finale. We're going to pull everything together. Ladybird deeds, trust, living probate documents, full planning stack, and most importantly, the one meeting that makes all of it work. If you've watched every video in this series and you are still not sure what your next step is, video 8 is going to answer that question. Remember that woman I told you about at the top of this video? The one who grew up in that house, who knew every squeaky floorboard? She didn't lose that house because she didn't love it. She lost it because nobody told her the tax bill was coming. That's a conversation this video is trying to start. Have it before you have to. This has been the Florida Real Estate Insider. I'm still Tom McNamara. See you in the next one.